Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Filing a lawsuit without a lawyer, which is called proceeding pro se, is a significant step, but it is a fundamental right in the American legal system. Before you even think about court, you should strongly consider sending a formal demand letter to the person or company you plan to sue, who is known as the defendant. This letter should clearly state who you are, what the problem is, what you want as a resolution, like a specific amount of money, and a firm deadline for them to respond. This not only gives them a chance to settle but also shows the court you tried to resolve the issue first. If that fails, your next step is to draft the initial court document, which is usually called a complaint or a petition. This document is your story to the court. It must contain several key parts. First, you need to identify the parties. You are the plaintiff and the party you're suing is the defendant. Second, you must explain why you're filing in that specific court, which is called jurisdiction. This is usually based on where the defendant lives or where the incident happened. Third, you'll write out the facts of your case in a clear, chronological order. Stick to what happened, when it happened, and who was involved. Fourth, you need to state your legal claims, known as causes of action, like breach of contract or negligence. You can often find templates or examples on the court's website. Finally, you must state what you want the court to do, which is called the prayer for relief. This is where you ask for a specific amount of money in damages or for the court to order the defendant to do or stop doing something. Once your complaint is written, you need to file it with the correct court, which is done at the clerk of court's office. You will have to pay a filing fee, but if you cannot afford it, you can ask the court for a fee waiver by filing a form often called an application to proceed in forma pauperis. After filing, you are not done. You must legally notify the defendant that they are being sued. This is a critical step called service of process. You cannot just hand them the papers yourself. You must have a neutral third party, like a sheriff's deputy or a private process server, deliver a copy of the complaint and a summons, which is an official notice from the court. Each court has very strict rules for how this must be done, so check your local rules carefully. Once the defendant is served, they have a specific amount of time to file their response, called an answer. This process is complex, and the rules of procedure and evidence are unforgiving. Court websites often have self-help centers and forms that can be a valuable resource. This video is for informational purposes only and is not legal advice. Thanks for watching. If you found this information helpful, please hit the like button and subscribe to our channel for more guides on navigating the legal system.